Proper estate planning is often overlooked until later in life. While planning for your retirement, it's a good time for you to get it right for both your benefit as well as the benefit of your loved ones. In managing retirement assets, we talked about the accumulation phase and the utilization phase. Now let's talk about the phase that involves transferring assets to family members and heirs. I want to begin by saying that there definitely is a better time to get these details taken care of than others. And that's before you need it, because when you need it, if it's not done, it's too late. So regarding estate planning, yesterday was the best time to do it. I want to point out that estate law in Louisiana is different than any other state because it's based on the Napoleonic Code, which our founders used to write the laws. Now, 4 legal tools you'll need for basic estate planning are 1, a will, power of attorney, medical power of attorney, and a living will. Let's go through all of those individually. The will is important because it declares and validates how you want your final affairs to be handled and your assets to be distributed. A will assures that your surviving spouse has the ability to control the community property assets that y'all accumulated during your marriage. Without a correctly structured will providing usufruct, the surviving spouse may well not have control over the community property. An effectively structured will provides for maximum protection from federal estate taxes. A will can contain a testamentary trust in order to protect children from having to manage what you leave behind. And a will prevents any disputes or ill will between your heirs, or at least it goes a long way in doing that. And this is a real big thing to give to your children and your grandchildren. Now, power of attorney gives someone else the legal right to act on your behalf financially if you can't. It's a very good idea for spouses to have this for each other, or for one of your responsible children to have this for you. Without it, your spouse or your child may have to go through the courts to get the right to act on your behalf financially, and that's just not a process you're going to want them to have to go through at a critical time. A medical power of attorney authorizes another party to make medical decisions for you, including end-of-life decisions, if you become incapacitated or otherwise can't make these type decisions. A living will makes your wishes known when it comes to life-prolonging medical treatment. It takes the form of a directive as it becomes part of your medical chart for your physician to appropriately use. It protects your family from having to make difficult, perhaps hard decisions at an already challenging time. And it's yet another valuable service you provide your family. At the end of the day, creating these estate planning tools is really just a gift to them. I think it's important to mention living trust. I meet people who have them from time to time, and I get a lot of questions about them. The purpose of a living trust is to avoid probate. At least that's the purpose of it in Louisiana. Basically, what you do is during your life, you transfer all of your assets into the trust. Now, I'm not an attorney and I can't give legal advice. But my experience has been that quality estate attorneys will tell you that if you have your affairs in order, probate's not a big deal. And the living trust actually aren't easy to maintain and take care of. It looks to me like some attorneys make a living promoting living trust. Friends, effective estate planning is what quality people do, and it's one of the signs of a well-lived life. Taking the time to accomplish the basic details of estate planning is really just about right living, and it provides a security and a big gift to your family and heirs.